Hello again, I'm Chief Judge Dan Greear, here with another Understanding the ICA video. Our effort to help everyone, especially non-lawyers, understanding the inner workings of the new court. Today, I'm going to discuss the ways appeals before the Intermediate Court of Appeals, or ICA, can be resolved. One way this can happen is by a dismissal order. A party to an appeal can file a motion to dismiss at any time after the appeal has been docketed. A petitioner, the party who filed the appeal, who no longer wants to proceed with their appeal, can move to withdraw the appeal, or the respondent, the party the appeal is against, can move to dismiss it. A respondent may ask the ICA to dismiss an appeal for various reasons, including that the petitioner has not perfected the appeal on time by filing the petitioner's brief and appendix, that the petitioner has not followed an order of the court or the rules of appellate procedure, or that the ICA does not have jurisdiction over the appeal. The ICA can also dismiss an appeal for these same reasons without a motion from one of the parties. Many appeals in the ICA will be resolved by a written decision. The court has two types of written decisions: memorandum decisions and signed opinions. Memorandum decisions are authored by the court itself, while signed opinions are authored and signed by a particular judge. Signed opinions are formally published and memorandum decisions are not, but both types of decisions will be posted on the court's website. Whether the court issues a memorandum decision or a signed opinion, the decision will explain the reasons for the court's resolution of the appeal. Both memorandum decisions and signed opinions have precedential value, which means that lower courts must follow decisions and that litigants can rely on past decisions in making arguments in future appeals before the ICA. However, signed opinions are stronger than memorandum decisions, so if a memorandum decision and a signed opinion resolve the same issue in different ways, lower courts and litigants should follow the signed opinion. Decisions of the ICA can affirm the lower court, which means that there was no error in the lower court's order that is sufficient for the ICA to change that court's decision. The ICA can also reverse the order of the lower court, which means that the ICA did find an error significant enough that the lower court's ruling must be changed in some way. In some cases, the ICA will affirm part of a lower court's order, but reverse other parts. Cases that are reversed will often be remanded, which means that they are sent back to the lower court for additional proceedings or for the entry of a new order. The ICA's memorandum decisions and signed opinions can both be appealed to the Supreme Court of Appeals of West Virginia. Once again, I'm Chief Judge Dan Greear. Thank you for joining us for Understanding the ICA, and I look forward to speaking to you in further episodes.